A federal prisoner claimed officers lost his stuff when he was transferred to a new facility. Sovereign immunity would normally bar a claim against the government, but the prisoner relied on the Federal Tort Claims Act, which consents to certain claims. Does an exception for claims regarding the detention of goods mean that sovereign immunity remains intact after all? Find out in Ali versus Federal Bureau of Prisons. Federal prisoner Abdus Shahid M.S. Ali was transferred from a Georgia facility to a federal prison in Kentucky. Before leaving, he packed 2 duffel bags of personal belongings. After Ali arrived in Kentucky, he claimed that some of his belongings were gone. He was missing 2 copies of the Quran, a prayer rug, and magazines. The Bureau of Prisons denied liability for the missing items. Ali sued the Bureau, alleging it had violated the Federal Tort Claims Act. The act authorizes suits against the United States for injury or loss of property caused by federal employees' negligent or wrongful action. The Bureau claimed that an exception exempting claims regarding the detention of property immunized it from Ali's suit. Under Title 28 of the United States Code, Section 2680, the government retains sovereign immunity for, quote, any claim arising in respect of the assessment or collection of any tax or customs duty or the detention of any goods, merchandise, or other property by any officer of customs or excise or any other law enforcement officer, unquote. Ali relied on the references to tax, customs, and excise functions. He asserted that the phrase any other law enforcement officer meant only officers that carried out customs or excise functions and excluded the prison officials who allegedly lost his property. The Bureau submitted that the phrase broadly granted sovereign immunity for property detention by law enforcement and thus included the prison officials. The district court agreed that the statute barred Ali's claim. The 11th Circuit affirmed. The Supreme Court granted cert.